Good morning, everyone. I'm Judge Blake Adams. We're here for several things this morning. We're here for my violation of probation dockets, as well as I'm covering for Judge Brown this morning for his criminal motion dockets. We have Ms. Bonilla for the state, as well as Mr. Rusinko. Good morning.
Good morning, Judge.
All right, we're going to cover the cases for people who are in the courtroom first, and then we'll move to those that are on Zoom. I think we'll try to cover the violation of probation docket first, because it should move the quickest, and then we'll move to Judge Brown. When the bailiff directs you up to the podium, please state your name. Good morning. All right, this is case number 19 CT 1892. You're here on a violation of probation for a DUI second offense.
Yes, sir.
Failing to provide proof of receiving a substance abuse evaluation and counseling. Have you gotten that completed?
Yes, sir.
Did you provide that to the probation office?
I sent the completion to my probation officer, and it's completed on the 8th session. And I don't have the completion for this.
Okay, hang on. Let's see the probation office.
We do have confirmation that you January 19th recommendation to the courts in the state to dismiss the VOP.
All right, Ms. Bonilla?
Yes, Judge, we did receive notification of his completion of the counseling. Therefore, we would like to dismiss the VOP.
Are you moving to dismiss the violation of probation?
Yes, Judge.
All right, motion to dismiss the violation of probation is granted. Is his probation terminated?
Correct. It terminated January 10th.
All right, very good. Does anyone have a proposed order for me to sign? Ms. Bonilla?
I do not, Judge. Can I email that to you shortly after the VOP hearings today?
Can you print to this courtroom?
I'm sorry, Judge?
Can you print to 1B?
One moment.
All right. Thank you, sir. Your violation of probation has been dismissed, and you're no longer on probation. You're free to go.
Thanks, sir.
All right, thank you. Have a good day.
Judge Adams, I'm sorry to interrupt you, but do you have a clerk? Because I'm showing like a clerk is trying to connect. So.
Well, I have a clerk in the courtroom. Thank you, Mr. Hopkins.
Yes, sir.
Michael McDonald.
Thank you. Case number 19 CT 1538. So you're here on a violation of probation for a DUI first offense. The allegations are the following: not reporting to the probation department each month as required, failing to report for the month of January, not paying the monthly probation fee, failing to provide proof of completion of the 10-day vehicle immobilization, failing to provide proof of 50 hours of community service completion, failing to provide proof of enrollment or completion of the victim impact panel, failing to provide proof of enrollment or completion of the DUI school, failing to provide proof of receiving substance abuse evaluation and counseling as recommended. Do you understand that you have the right to an attorney, and if you cannot afford one, I would appoint one to represent you? All right. You intend on proceeding without an attorney, hiring an attorney, or do you need me to appoint one? All right, I'll make a temporary appointment of the public defender. Do I have Ms. Armpriester there?
Yes, Judge. At this time, if we could please enter a denial and set for status in front of the appropriate judge.
Okay. All right, sir, the public defender has requested that we set this for a status to give you some time to speak to them and maybe get some of that stuff done. So your next court date will be February 23rd at 10 a.m. What I want you to do before you leave the courthouse today is go across the hall where it says customer service. Tell them you need to apply for the public defender, complete that application and turn that in. If you're approved, make sure you stay in contact with whoever your assigned attorney will be in the public defender's office, okay? All right, their office is located on the 5th floor if you need to go up there. Good morning. Clark, 19 CT 2957. All right, you are here on a violation of probation for a DUI offense. The allegations include that you failed to provide proof of a substance abuse evaluation and counseling as ordered by the court. Were you able to get that completed? All right. Did you provide that to the probation officer? Okay.
At this point, we do not have proof that he completed it, so we're in a position to court to grant continuance to give him time to show us that proof.
All right. Sir, would you like to enter a denial of the violation of probation and get the proof necessary to provide to probation? All right, we'll go ahead and enter a denial. When will his next court date be? March 2nd at 10 o'clock. If you feel like you need an attorney, you do have the right to an attorney, and if you cannot afford one, I would appoint one to represent you. So if you need an appointed attorney, you can go across the hall where it says customer service and fill out that application. Okay, sir? All right, thank you, sir. We'll see you back on that date. Good morning. All right, this is case number 19 CT 2608. You're here on a violation of probation for a DUI first offense with breath alcohol content of 0.15 or higher for failing to pay the monthly probation fee and failing to pay fines and costs. Looks like there are some other outstanding conditions. Do you understand that you have the right to an attorney? If you cannot afford one, I would appoint one to represent you. Do you intend on proceeding without an attorney, hiring an attorney, or do you need one appointed? All right, I'll make a temporary appointment of the public defender. Ms. Armpriester?
Yes, Judge, if we could please enter a denial and set this for status in front of the appropriate judge.
All right. All right, March 9th at 10 o'clock. That'll be your next court date. What I want you to do before you leave the courthouse, go across the hall where it says customer service. Tell them you need to complete an application for the public defender. Fill that out and turn that in, and then stay in contact with the public defender before your next court date, okay? All right, thank you, sir. All right, that's it for everyone who's in the courtroom. Let me go to Zoom. Is there anyone here on the Zoom channel that's here for the violation of probation docket?
Your Honor, are you in courtroom 1B?
That's correct.
I am printing an order now for case number 19 CT 1892.
Okay. All right, Ms. Armpriester, looks like you've got one case on the docket, on the 9 o'clock docket for the VOP docket. Let me take a look at that.
Yes, Your Honor, I am pulling up the name now. Halfway through the docket, Judge, I got kicked out of showcase, and trying to get back in has proven difficult. Judge, I see that my colleague, Mr. David Wilson, is appointed to Hector Lazaro Rodriguez, 18 CT 143. He's in custody. If we could enter a denial and set this for status in front of Judge Provost, please.
All right, when will his next court date be? All right, March 16th at 10 o'clock for a status.
And Judge, can I get the case number for that case one more time?
18 C. Sorry.
18 CT 143.
Received.
All right, and in Madam Clerk, in case number 20 MM1765, Kevin Israel Castro Salinas, his private attorney has filed a written denial. Set his case for status. March 2nd. All right, did you get that, Ms. Bonilla?
March 2nd on at what time, Your Honor?
10 o'clock
Received.
for a status. And Ms. Bonilla, I did receive your order on Tillery. I did sign that.
Thank you, Judge.
All right, the rest of the docket for 9 o'clock on the VOP docket are unrepresented. We'll go ahead and recall those cases later. All right, let me go to Judge Brown's docket. Madam Clerk, you'll let me know when you're ready to switch over.
Yes, Your Honor.
All right, let me go to Mr. Verderamo.
Good morning, Your Honor.
Good morning.
Gregory Clifford, 20 CT 401. It's a request to terminate Mr. Clifford's probation early. I did receive notification from Nancy Mondahalo over a county probation that all conditions have been completed. Restitution has not been established. And as of January 20th, all fees have been paid.
All right, state have any objection to the motion for early termination of probation?
No objection, Your Honor.
All right, without objection, the motion for early termination is granted. I did receive a proposed order. I'm signing that now.
Great, thank you. Have a nice day.
All right, thank you, Mr. Verderamo. All right, let me go to Mr. Hopkins. Good morning.
Morning, Your Honor. Your Honor, I have a plea, so I'll defer to the other attorneys if that's okay.
All right, thank you. Let me go to Mr. Gorman. Good morning.
Morning, Your Honor. We have two motions to early terminate. First is Miguel Sanchez, 20 CT 480. He's completed all outstanding terms and conditions. We have an email from Ms. Mondahano indicating that he's up to date on all probation fees as of January 11th. This time we'd be moving to early terminate.
Any objection?
According to my information, he still owed $75. Is there a anyone for probation there?
Yes. Good morning.
Good morning, Judge Renato, County Probation for the record. Yes, it does owe $75.
Mr. Gorman, I don't know if you could hear that. County probation is indicating that he still owes $75.
Yeah, my email's dated January 11th, so maybe between the 11th and today, another cycle kicked in, and that could account for it. So, Judge, if we could send over an order granted upon payment of remainder $75, we'll get that paid today.
All right, any objection?
No objection, Your Honor.
All right, order granting motion for early termination of probation upon the payment of the $75 fee is granted.
Thank you, Judge. Next, we have Vladimir Rodriguez, 20 CT 315. Similar situation. He's completed outstanding terms and conditions. At this time, we're moving to early terminate.
Any objection?
I believe this one, there is a $75 fee owed as well.
Judge, sometimes when we set them and we get word everything's paid, then it kicks in shortly thereafter. So we'd have the same request then, Judge, if that's probation's position, that it's still outstanding.
On the 14th of January, another $75 to June.
All right. All right. So on January 14th, another $75 did kick in. Any objection to granting the motion upon payment of the fee?
No objection, Your Honor.
All right. Motion for early termination of grant is granted upon the payment of the $75 fee.
Thank you, Judge. Have a good day, Your Honor. We'll get the order to your chambers and CC the state.
Okay. Very good. Thank you.
Thank you.
All right, let me go to Mr. Lucarelli. Good morning.
Good morning, Judge. This is a motion to grant leave to take depots.
Okay, pull that up.
Ruley is the defendant, and I tried to spell things out in my motion. I will just make a couple of points.
All right, this is case number 20MM1592.
Judge, the victim and his son. I guess the victim allegedly one officer says his English was okay. The other officer says he didn't speak very good English, but the son translates and later gives a different version of what happened, or includes other things later on in a written statement and as well as orally to the officer at the station. If we look at the discovery, all I have is a brief statement. The statement I have that's written, supposedly the victim's statement, is written by his son. I'd like to question the son about what he knows of what happened there and how he came to write that statement. The statement is pretty well written. There's no mention. There's a photo of a bruise on one of the pages of discovery. It's a pretty bad bruise. There's no mention of a kick or any injury. He's not limping, and he's not mentioning anything like that to the officers there at the scene. And then later on, we do see a bad bruise there. So I would imagine if this were to go to trial, and the jury found him guilty, the state might be asking for jail. There's also there are four other witnesses, four other deputies that were there that did not include statements. I'm not interested in talking to them. I think that I can get by with just these two depots, but these two depots would help me resolve the case, I think.
All right. Mr. Rusinko, what's the state's position?
The state would object based on the fact that the son didn't witness the battery. He just went down to the police station with his father to translate. The father speaks Albanian, and apparently English is not his main language. So he completed the form, the statement for his father in English, and merely just relayed that to the police officer.
Brief response, Mr. Lucarelli.
Judge, I think that bolsters my reason for talking to the son. I would like to know what this. I'm sure the father told the son more than that. It wasn't just a clear translation, as if we had a translator there who said, "Tell me what happened." He spent some time talking to his son, and he didn't go to the sheriff's office until later. And then you have the conflict as to what he told the first officer and what's in the statement. There's no mention of the kicking or bruising or any injuries at the scene there. And later on, he turns up with a big bruise on his leg. Judge, these two also have a history. They don't like each other. My client thinks that this is just him trying to get back at him for some other job that he did. They worked together and he owed him money or something along those lines.
All right, which one is the son? Is that Georgia?
Son is Ari.
Oh, Ari. All right.
Jorgo is the victim. That's the dad.
All
Ari
right.
Alexander Gika is the son.
At this time, I'm going to grant the motion in part as to the son, Ari Alexander Gika, and deny as to Jorgo Gika. Of course, that is without prejudice, depending upon the deposition taken with Ari.
Very good. Thank you, Judge.
All right. Thank you, Mr. Lucarelli. If you could send that over to my judicial assistant, we'll get that filed today.
If one hasn't been filed already, Judge, I'll get one over today. Thank you. Have a good day.
Thank you. You too. All right, next let me go to Mr. O'Brien.
Good morning, Judge.
Good morning.
Judge, not to interrupt, may I please be excused until the 10 o'clock docket?
Do we have anyone else here for a violation of probation? Without answer, yes, Ms. Armpriester.
Thank you, Your Honor.
Oh, thank you. We'll see you back at 10. All right, go ahead, Mr. O'Brien.
Judge, I've got two matters before Judge Brown this morning. If I may start in reverse alphabetical order, I've got Juan Pablo Garza. Judge, he is present. We set a motion to suppress. We calendared that for March 2nd at 11 a.m. If possible, could we also set a pretrial conference at that same moment?
All right, and for the record, this is case number 20 CT 1415. All right, I do see that this was set for a pretrial conference today. I do see the notice of hearing for the motion to suppress in the court file. Any objection to continuing this case to March 2nd at 11 a.m. for a pretrial conference at the same time as the motion to suppress?
No objection, Your Honor.
All right, so ordered March 2nd at 11 for pretrial.
Judge, I also have Brandon Anderson. My request for this would be if it's acceptable to the court and the state to continue that with a waiver. We hope to reach a resolution, and perhaps the court could set us on that same March 2nd date, and we may end up being able to resolve that with a plea at that time.
Give me one moment here.
Yes, Your Honor.
I'm just pulling up Judge Brown's calendar. Any objection to that, Mr. Rusinko?
No objection, Your Honor.
All right, we'll go ahead and set that case for pretrial conference on March 2nd at 11 o'clock also.
Great, I appreciate that. Thank you. Mr. Garza, you can turn off now. Your case is.
Thank you, Mr. Garza. All right, thank you, Mr. O'Brien.
Have a good day, Judge.
Thanks, you too. All right, let me go to Mr. Hopkins again. Good morning again.
Good morning, Your Honor. I'm here actually on three matters. So what was said at 9 o'clock, I have a plea. I have a motion to early term probation that was docketed at 10. So I know you have a probation representative, so I can take it in whatever order the court wants to.
Let's take Camuso first.
Yes, Your Honor. So this is 20-425 CT. This is a plea. It'll be a plea in absentia. You'll see docketed and showcase, and Madam Clerk, you'll see it as well. January 15th, a plea in absentia. He's going to be pleading as charged. So at this time, Your Honor, I would withdraw his previous entered plea of not guilty, and he'll be entering a plea as charged. Count 1, leaving the scene of a crash, attended property. Count 2, DUI under the influence, first offense with damage to person or property. This was negotiated with Ms. Karimi. You'll see at the back of the plea in absentia, she's reviewed, she's signed, it has her signature there. The terms are before the court. What I would point out specifically as to count 2, well, count 1 and count 2, it's a proposed concurrent probation sentence as to both counts. But if you look at count 2, specifically, Mr. Camuso waived his right to petition the court for early termination. So the language of no early termination, that is correct. As to the 10 days county jail to be served on the weekend work program, if he's eligible, I've explained that, as has Mr. Berry, but he's specifically waiving previous jail credit. So that's contained in the plea in absentia as well. There's a separate paragraph where he's waiving any previous jail credit. And then there's a proposal of 30 days sober length following the weekend work. So I just wanted to point out those three things because that's a little bit of a deviation. So I just wanted to point that out to the court.
All right, thank you, Mr. Hopkins. Natalia, you'll let me know when you're ready.
I'm answering the questions.
Okay, thank you. We're just waiting on the clerk to give me the go-ahead.
Yes, Your Honor.
That's okay.
And I'm sorry to interrupt you earlier about your clerk.
Oh, that's okay, Mr. Hopkins.
I saw somebody connecting and I thought, oh, that'll be bad if Judge Adams has to go back and pull court smart. So
that would not be fun.
The restitution, the court is served. Restitution.
Court will order and reserve restitution to Jose Arjona and Karina Bernal. All right. Mr. Rusinko, I see that Ms. Karimi has signed the plea in absentia. Any last minute objections before the court accepts it?
No, Your Honor.
All right, Mr. Hopkins, will you stipulate to venue and a factual basis for the plea in absentia?
yes, Your Honor.
All right, I'll accept the plea in absentia, find it knowingly, voluntarily, and intelligently entered upon a factual basis and in the defendant's best interest. Sorry, give me one moment. As it relates to count 1, the court will adjudicate guilty, place the defendant on probation for a period of 6 months with no early termination, and the following conditions. Probation shall run concurrent with the probation ordered in count 2. The defendant will be subject to random testing at their own expense. There will be no possession or consumption of alcohol provision, meaning they cannot consume alcohol, they cannot have alcohol in their residence, they cannot go anywhere that primarily sells alcohol, such as bars, taverns, saloons, or packaged liquor stores. All costs will be imposed, including court costs and costs of prosecution. As to count 2, the court will adjudicate guilty, impose a 6-month driver's license revocation, place the defendant on probation for a period of 12 months with no early termination. There will be, as a condition of probation, 10 days of jail with no credit for time served, which may be served on the weekend work program, weekend lockdown, or straight time. 30 days of continuous SoberLink alcohol monitoring to begin after the weekend work or after the jail sentence. A $1,000 fine. The appropriate DUI school must undergo a substance abuse evaluation and follow all recommendations. 50 hours of community service, 1 victim impact panel, 10-day vehicle immobilization, random testing at their own expense, a no possession or consumption of alcohol, meaning no alcohol in the residence, no consuming alcohol, no entering any businesses that primarily sell alcohol, such as bars, taverns, saloons, or packaged liquor stores. The court will order and reserve restitution to Jose Arjona and Karina Bernal. All court costs, including costs of prosecution, shall be imposed. Probation in the sentence shall run concurrent with the probation in count 1. Give me one moment to review all of that. Looks good. All right. All right, and you want to go ahead and we'll address your next case.
Yes, Your Honor. If we could go to Sarah Theory, 20 MM 527, Mike Hopkins for Miss Theory. Your Honor, this is a motion to terminate probation. And when you have it, I'll proceed. I know you're reading. I'm pulling it up.
Okay, I've got it.
Okay, so she was sentenced to petty theft, second or more, on July 1st. She was sentenced to 12 months probation with the possibility to early term after 6. That was specifically negotiated that she would have that ability. As part of her sentence, she had to complete a shoplifter's alternative program, 50 hours of community service, pay restitution to Publix. The allegation was 4 bottles of wine were taken from Publix, so she paid the restitution amount. She, to my knowledge, and the indication we've received from probation and Miss Theory is that she's completed all terms. She actually mistakenly did the wrong shoplifter's alternative class, so she had to go back and do the correct one. So she's received double the education. She shouldn't get credit for it. I'm just pointing it out, that as part of this, that's what she's done since the plea. She is just over half I am respectfully requesting that the court consider a request to early terminate.
All right, what is the state's position?
No objection from the state, Your Honor.
All right, without objection, the motion for early termination of probation is granted. Probation shall terminate immediately.
I'll submit an order to you,
All right,
Your Honor.
very good.
And the final case that I have, Your Honor, this is Austin Kellam, Kellam, 20MM1454.
Okay, go ahead.
Your Honor, this is a motion to take depositions. This is actually the defense second motion to take depositions, and I'm seeking to depose two separate officers. One would be the arresting officer, Shankali, from the Naples Police Department. The other is the Grenice, who is the backup officer. I can tell you the reason I did not make that request previous to Judge Brown is because my default is that if there is an arrest report that's being submitted, unless I have really good grounds to go back and go past the arrest report, I rely on the arrest report. So, previous, whenever I had made the request to depose the alleged victim in the case, the charge is battery. It was primarily, based on what our client was claiming as to his defense, but then also the fact that the alleged victim had never submitted an arrest report, or excuse me, a sworn statement. The reason I'm requesting to depose these two individuals at this time is subsequent to Judge Brown granting the defense initial request to depose the alleged victim. That discovery took place. There were additional efforts by the defense where three separate witnesses were identified. They've been disclosed to the state. Two of the witnesses will testify, and I expect they will testify at trial and at a hearing that the alleged victim was the aggressor, threw the punch, and the defendant was acting in self-defense. The two individuals were security guards at the time. So as to these particular officers, who's the easier one, I'll take Grenice first. He did not write a statement. He's been listed as a witness by the state. I want to know what his observations were as it pertains to the battery. That's the primary reason. As to the arresting officer, the main reason I'm seeking to depose him at this time, even though he has generated a limited probable cause affidavit, is two of the witnesses that the defense identified. One was a gentleman by the name of Stevenson Dort. The other is a gentleman that I identified right after the new year, or right around the new year, Mahim Robles. Both of them were security guards at this restaurant. They both indicated that the arresting officer had a bad vantage point of what happened for purposes of this battery. Both of them separately, being interviewed outside of each other, indicated to me that the alleged victim was the aggressor. They both indicated they went up to the arresting officer and said, "Hey, here's what we saw. This gentleman shouldn't be arrested," and indicated they would make a statement to law enforcement. So the $1 million question that I have for the officer is, what was his vantage point? Where was he at whenever he observed the alleged battery? And why didn't he further investigate what these security guards were telling him from the restaurant? Now, the third reason is in his probable cause affidavit, the arresting officer states that the alleged victim was too intoxicated to write a sworn statement at the time. So that indicates to me that that's a pretty heavy level of intoxication. That's what he's written in his probable cause affidavit. The alleged victim in his deposition categorically denied, that being the case. So it also goes to impeachment evidence just to make sure that indeed was the case and not a typo or anything else. Where this is leading up to is a stand your ground motion, which I expect will be at least half a day, possibly a day. And I really, in preparation, I don't want surprises, but to prepare and make sure there's a good faith basis to proceed with that motion. That's the reason for the request.
All right. State's position?
Your Honor, the state would object. simply because the arresting officer completed an arrest report, and the other officer, Granisi, as indicated in the report, wasn't on the scene at the time of the battery took place. No further argument.
All right. Any last response, Mr. Hopkins?
No, Your Honor. Your Honor, I didn't, well, I take that back. I didn't see the language that Granisi was not on scene. I'm not disputing what, the state just said. I just didn't see that. So I would ask the state, is that in the probable cause affidavit? Because if that's indeed the case, then I would agree. I don't want to waste the officer's time, but the only thing that I see in the probable cause affidavit is that the state has listed him as a witness to a battery, and it just says that he put the individual in the handcuffs. That's the only thing that I see.
Mr. Hopkins is correct. What I was reading was multiple officers arrived on the scene, and then Officer Granisi placed Mr. Kellum in handcuffs. It does not specifically say he wasn't on the scene, but initially it's just the arresting officer's report that he was there and saw the battery.
All right. Based on the information provided by Mr. Hopkins, as well as looking at the court file and the orders that Judge Brown has entered in this case, the court will grant the motion to take depositions of both officers.
Yes, Your Honor, I'll submit an order.
Very good.
Thank you.
All right. Anything else, Mr. Hopkins?
No, Your Honor. Have a good day.
All right. Thank you. You too. Take care. Let's see. Give me a minute here. All right, Mr. Rusinko, you have a motion to reissue bench warrant in State of Florida v. Don R. Smith, case numbers 15 CT 263, 15 CT 492, and 15 CT 1567.
Yes, Your Honor.
These were bench warrants that expired, and we will still be prosecuting these cases, so we're asking to reissue the bench warrants.
Has the state done any research as to where Ms. Smith is, or if she is still living, or if she's in custody somewhere?
I do not have that information at this time, Your Honor.
Well, I'll go ahead and grant the motion to reissue the bench warrants, but those might be good answers to have before even filing a motion to reissue a bench warrant. Obviously, if she's deceased, there's no reason to keep the cases active.
Yes, Your Honor.
All right, I'm signing the order to reissue the bench warrants in case 15 CT 263, 15 CT 492, and 15 CT 1567. Any other cases we can address, Mr. Rusinko?
Not on my end, Your Honor.
Okay. All right, so we'll be in recess until 10 o'clock, and then we'll come back. We'll probably handle the docket first, and then, or at least those in the courtroom, and then we'll see who we've got for Judge Brown's docket.
All right, thank you, Your Honor.
And actually, Ms. Bonilla, are you there?
Yes, Judge, I'm here.
Do you want to go ahead and recall the 9 o'clock VOP docket? Or do you want to wait and see if they show up?
If it's okay with the court, we can give it another 10 minutes and see if anybody shows up.
All right, we'll just wait until we come back from our recess.
No problem, Judge.
And
Yes.
Your Honor, my apologies. The defendant in the Dawn Smith case is not deceased. I did just find that out. My apologies for not having that when you asked.
Okay, all right, very good. Thank you for that information.
Thank you.
All right, we'll be in recess till 10 o'clock. Thank you. Thank you. All right, good morning again, everyone. We're back on the record. Judge Blake Adams, I have a violation of probation docket this afternoon, as well as covering for Judge Brown's criminal motion dockets this morning. All right, let's go back to the violation of probation docket. We'll go to the 10 o'clock docket. Madam Clerk, are you ready to proceed?
Yes, ma'am.
All right, Ms. Armpriester, good morning again.
Sorry, if we could start with this Beverly McGilvey, case 19/2025.
All right,
Judge, as of yesterday, she had a $7 balance. She owed $270 submitted over that amount of community service hours. The balance this morning still reflected $7. We reached out to Madam State. She wasn't willing to drop it till we got here. Ms. McGrovey has been taking this very, very seriously. She also was missing work with overtime. She went ahead and paid $7. So she has zero balance and we're asking about the warrant activity.
what's the state's position?
Judge, the state is in agreement with defense counsel, and at this time, we move to dismiss the VOP. I'm printing an order to your courtroom now.
All right, the court will grant the motion to dismiss the violation of probation. I assume Ms. McRoby is no longer on probation then?
Correct, it expired October 20th.
Okay, very good. All right, thank you, Ms. McRoby, for getting everything completed. Your case is completed and you're free to go. All right, thank you, take care. You may, thank you, Ms. Armpriester. Thank you, you too.
Good morning, Your Honor. Speaking over to the public defender's office, I believe that I can fill out the rest of the probation cases for this morning.
Good morning, Ms. Woodley.
Starting with the.
Do you have the person that's in the courtroom?
And 19, CT 2183, I do represent Mr. Reeves. If we can have this set for a hearing date, please.
All right.
What case is this?
Travis Reeves, 19 CT 2183. Ms. Woodley is requesting a hearing. All right, so our next court date is, okay, March 2nd at 10 o'clock for a violation of probation hearing. Any objection?
No objection, Your Honor.
All right. All right, thank you, sir. We'll have you sign for that.
All right, starting from the top of the docket.
Okay.
Dottie ran, I believe it's Brand Peter in 15 BT 2930. This is a veteran agreement here. She has 60 days of credit she already has in on this case. I ended up asking them for status because of conflict of concern that this status is being asking based on the amount of credit, she maxed out on credit instead of going around and go with spending funds on hiring experts, but at this time, since they're not willing to dismiss it, I'm providing them to go and getting an expert for an evaluation. So I'm asking for to see that for status so I can motion the court for an expert to evaluate it.
Ms. Bonilla?
Judge, I'm not sure what defense counsel is asking. I can barely hear her. Is she asking for continuance so that her client can get evaluated?
I didn't file, Ms. Bonilla, I didn't file a motion yet, but that's my plans for this case is to get an evaluation. I just wanted the court to be aware of it. This is a second degree senior and she's got 60 days to max out on credit for this. So I'm not sure what your offer even is, but she maxed it out.
Is your client in custody?
She's not.
Okay.
She's been under a day draft.
Okay. Any objection?
I don't have an objection to a continuance, Your Honor.
All right. And you wanted a status?
Yes, Your Honor.
All right, March 2nd at 10 o'clock for status.
Next would be Gary Castillo and the cases in 2016-1656 and 1269. We have this resolution we'd like to the global resolution to go to see if we can set them on. We got it about 2:15 this week.
Is he in custody?
He is in custody.
The court has no objection to setting it on a 2:15 docket. State?
Judge, is there a reason for setting it on the 2:15 docket? Is she wanting to plead this case out?
Yes, he would like time for it.
Well, she can't hear you, so.
Oh, thank you, I appreciate it.
Yes, she requested a 2:15 docket for a plea, or an admission, I guess.
No objection, Your Honor.
All right, so here's what you're gonna have to do. We're gonna continue it to, what was our date? March 2nd at 10 o'clock. Ms. Woodley, you'll need to reach out to Judge Brown's judicial assistant, let them know, and I'll let her know also that I have no objection to this being set on a 2:15 docket this week.
Thank you, I appreciate it.
And that'll be for both cases.
Okay, Judge, and this is set for status, just a control date on March 2nd?
Correct.
And next would be Laura Davis, 1961-561. She is currently at the Willow. She has certificate of completion for the Willow, as well as paperwork to present to court to show where she's at. Ms. Bonilla, I was hoping to speak to you about this to see if there was an offer that would include the Willow. I think she's her current situation is done as much as she can on probation.
Well, that should have been done before the proceeding.
I did just receive this from my computer. I didn't record this date sooner.
So what are you requesting, Ms. Woodley?
A continuance, and if Ms. Bonilla could send me over an offer for what she wants to do with Ms. Davis.
So this was marked as final continuance.
Yes, I do see it as final continuance.
Shall we?
I don't know if she's going to be actually still at the zero. When exactly she's going to be out. My concern.
Should we set it for a hearing?
I asked that we don't, just because I don't know where she's going to be. She's trying to get to residential treatment over her condition.
Bonilla?
Judge, the state is going to object. A plea offer was sent to Ms. Woodley last week in regards to this case. Furthermore, as the court has noted, this status docket was marked as file continuance. So I'm hoping that the court will be inclined to set this for a hearing on the next hearing docket.
All right, let's set it for a violation of probation hearing for March 2nd at 10 o'clock. We worked out a plea agreement. Obviously, the court will entertain that. Or if you need to file a motion to continue pursuant to the Florida Rules of Criminal Procedure, Ms. Woodley, attaching an affidavit or documents to support that motion, the court would entertain that as well. All right.
And last, the Elijah record 20M 1064. I can get a continuance. There's another case that is this other attorney waiting for this special, and it does affect this case.
Is it a felony case?
Yeah.
Any objection?
Judge, this is for Mr. Elijah Rickford.
Yes.
She's asking for a continuance, Your Honor.
Yes, based on this felony case.
No objection, Your Honor.
All right, March 2nd at 10 o'clock for a status. Ms. Woodley, I'm showing one other case for you. Richard Schaefer, 19 CT 1809. Let me just check to make sure.
Violation of
Showing it's still pending.
Oh, you know what? He is trying to get paperwork showing. The only thing left is his vehicle impound and days, but he got sick. It was 2 weeks, the last 4 days he was sick, so he hasn't been able to get his paperwork showing that it was notarized for his pending vehicle impound. He's requesting his been moved on.
Judge, if the state can be heard.
Okay.
Case number 19 CT 1809. I've been informed by probation that conditions have been completed, and therefore the state would like to dismiss the VOP.
Correct. We have everything.
All right. All right. Court will grant the state's motion to dismiss the violation of probation, and probation is dismissed. All right, Ms. Benio,
Taking that order now.
All right, thank you. And then I believe that's all of your cases, Ms. Woodley. All right, so we have trial set for this afternoon. What is the status for that?
So, and I think I said this to a couple days ago. My client is trying to get into diversion, but Mr. Cruz keeps telling him that he's waiting for the state to send over the slip for diversion and new slip and new agreed upon terms, and that was the last time he called was on Friday. This when he called Mr. Cruz and was told that he was waiting for him. That's the status. Doesn't want to enter the diversion on the agreed upon terms, but the holdup is Mr. Cruz.
I do see that a deferred prosecution program routing and receipt was sent on January 22nd.
And I saw that as well, but he did just call on Friday and
Ms. Bonilla, do you know what's going on with that?
Judge, I'm working it out right now. I'm going to get it straightened out. I did send a new contract reflecting the new terms last week. For whatever reason, probation, it's just, I got to discuss with Mr. Stewart. But other than that, from my understanding, there's no trial today just based on the defendant entering diversion.
Okay, all right. So we'll have some answers at 1:30 then?
Yes, Judge.
Okay. All right, we'll see you back at 1:30. Thank you, Ms. Woodley. Thank you, too. Thank you. All right, that leaves one case left on the 10 o'clock docket. Sean Elliott Ward, 19 CT 1137. Has probation had any contact with Mr. Ward? Sean Elliott Ward, 19 CT 1137.
Mr. Ward is in custody.
Oh,
I thought, last I checked, he's got a lot of credit.
was he the one we were going to try to?
Ward, John Ward, he's crossed out.
Crossed out? Do we?
I have this, I thought he was pro se also.
I'm showing that he's pro se, yes. Yeah, can you check on him? All right, let's recall that one. We're gonna check to see what his status is in the jail because he's crossed off of our list, so that may mean he's in isolation. All right, Madam Clerk, can we go back to the 9 o'clock docket?
The 9 o'clock?
Yes, for the violation of probation docket. You're ready? Okay. Back on the 9 o'clock docket, Ms. Bonilla, Jasbo Garcia Gomez, 19 CT 1996.
Judge, the state is going to ask continue this matter to your next VOP status docket. The defendant needs time to complete their counseling.
Well, the defendant's not here. Probation, have you had any contact with?
You can double check. I have him listed as a mail-in from Davie, Florida. So he is out of county, last I checked.
Okay.
Let me open it up and see if there's any new notes. Let's see.
I may not have, when I signed the order for him to appear, I may not have given it enough time to reach him. I didn't notice that he was out of county.
Yeah, so after 12, 26. Court date. I have him at 8300 Southwest 27th Place. I don't know if anything's returned from the clerk.
I'm not showing anything.
The last two report forms have that same address. Last three report forms. Back 6 months, it's the same address.
Okay.
No apartment number.
All right. Well, Ms. Bonilla, you want to continue it to the next VOP docket and see if he shows up,
Yes, Judge.
or see if he completes or provides proof of this substance abuse evaluation. All right, let's continue it to March 2nd at 10 o'clock for a status. No, wait, this is for arraignment, isn't it?
You want to put it 2 weeks, 3 weeks away?
No, let's go ahead and put it on the, let's go ahead and put it on the March 2nd arraignment docket at 9 o'clock. All right, next is Joaquin Toledo Hernandez, 19MM 2063.
Judge, can I get that case number one more time?
19MM 2063. It's any contact, anybody in probation heard anything from Mr. Hernandez?
I'll double check now. Sorry, what was the name again?
Joaquin Toledo Hernandez, 19MM 2063. He's in isolation. Oh, okay. Did you, so what did that mean that his name was crossed? Hang on. Ms. Bonilla, as it relates to Joaquin Toledo Hernandez, do you want to do the same thing on that one as we did for the previous one?
Yes, Judge. Is it a notice issue regarding this defendant?
Yeah, it looks like it was sent less than 2 weeks before today's date. That would be my fault.
No problem, Judge. No objection to a continuance.
All right, let's continue to March 2nd at 9 o'clock for VOP arraignment. And that brings us to Marcos Zuel, 19 CT 1700. Looks like he bonded. Probation had any contact with Mr. Zool?
I'll double check. What was the case number again, sorry?
19 CT 1700. Showing he bonded January 16th, shows a court date of January 26th at 9 o'clock.
Yeah, because the warrant was issued January 12th and signed. Judge Nicola. They would have given him the court date to, once he bonded. I don't have anything new other than that's on the affidavit.
The only thing, Madam Clerk, I'm seeing that a notice of appearance was filed, but no attorney is listed.
The notice of you?
Notice of appearance by Kristen Roger. Do you see that?
It was prior to the serving of the warrant, maybe that's why. Let me go into the case. Bodies as.
I just sent him an email, Your Honor, to
All right, well, it looks like he's got counsel. Looks like Kristen Roger filed a notice of appearance, but the notice of appearance hit before the executed warrant.
I already fixed that.
Okay, all right, so we'll consider that a written denial, and we'll go ahead and set that on Judge Nicola's next VOP date for a status. March 23rd at 10 o'clock
That's correct.
for status. All right, we are going, that should conclude the 9 o'clock docket, is that correct?
That's correct.
All right, and then Ms. Bonilla, we're gonna go back to the 10 o'clock to Sean Ward, 19 CT 1137. The jail is bringing him over. We've got our Polycom up. He's not in the courtroom yet. Is there an offer to resolve this case? The jail has informed us that he has 325 days credit.
He does, Judge.
Do you have an offer for him?
Yes, Judge, I do have an offer. Would you like me to announce it or wait for his appearance?
No, just go ahead and tell me what it is.
The offer at this time, Your Honor, is a year in the county jail, credit time served, revoke probation with conditions outstanding.
while we're waiting for the jail, I'm gonna make a quick phone call. Okay. All right, we're back on the record. We are back for violation of probation hearing docket. We have Mr. Sean Elliott Ward, case number 19 CT 1137. Good morning, sir.
Morning.
All right, sir, you're here on a violation of probation. Give me a moment to pull that case up. This is for a DUI second offense with breath alcohol content 0.15 or higher. The allegations include not paying the monthly probation fee, failing to pay fines and court costs, failing to pay restitution to victim 2, failing to refrain from the possession of any alcohol beverage, failing to provide proof of enrollment or completion of the DUI school, failing to provide proof of completion of mental health outpatient counseling, failing to provide proof of enrollment and or completion of the victim impact panel, and failing to provide proof of completion of the 10-day vehicle impoundment. You're charged with a first-degree misdemeanor. It's punishable by a maximum sentence of 1 year in the county jail. Do you understand you have the right to an attorney, and if you cannot afford one, I would appoint one to represent you?
Yes, Your Honor. I have Mr. James Thomas representing me. He's not there this morning.
Mr. Zonas has not filed a notice of appearance.
Okay, he was here for my last 2 court dates, but at this point, Your Honor, I have so much time in on the charge. I'm comfortable speaking to you on that.
All right. So, according to the information that we received from the jail this morning, you have 325 days credit. Does that sound correct?
Yes, Your Honor.
All right. And I have Ms. Bonilla for the state with us here this morning, and she's indicated an offer to resolve your case today. That offer would be to revoke probation and sentence you to 12 months jail with credit for time served with conditions outstanding.
Well, right away, I would not like to accept that. I wanted to point out a couple of things on the allegations of the violations.
Okay, all right, I'm gonna stop you there. Everything you say is being recorded, okay? So, and we're not here for a hearing on the violation of probation allegations. So if you don't want to admit to those, we can go ahead and set that for a hearing.
Well, to my understanding, I'll max out before that even occurs.
Well, that could be, which you'd be released then upon proper motion, and we could still have the hearing.
I just take the year and get it over with, save myself $6,000.
Have you read an admission form?
I have in the past.
All right, Naples Jail, do you have a violation of probation admission form there that he could read?
Yes, we do.
All right, very good. All right, Mr. Ward, let me know when you've finished reading that, okay? While we're waiting for Mr. Ward, let me ask, Mr. Rusinko, are you still there?
Yes, Your Honor. Sorry, trying to hit the button.
That's okay. So I'm looking at Judge Brown's 10 o'clock docket. I'm still showing 2 cases on there.
Yes, Your Honor.
Do you know the status of those cases?
The 10 o'clock, I believe we had a pro se motion, and then there was a motion by Mr. Carney.
Okay, all right. I have reached out to my judicial assistant to try to find out from Judge Brown's office if we know if Mr. Carney will be joining us or if the unrepresented person will be joining us.
Thank you.
Okay, all right. Thank you, Mr. Rusinko.
Okay, that is for the influencer.
Wait. Let me look at that again. Why would jail be a condition of probation?
We have to put that, so the probation order,
Because we're revoking probation. So it couldn't be a condition of probation.
is not, okay.
Okay. I'm sorry? Okay. Mr. Ward, are you finished reading that form?
Yes, Your Honor.
All right. Could you raise your hand to be sworn by the clerk?
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Will you state your name for the record
Sean Elliott Ward,
and your date of birth?
124.
All right. And again, the offer to resolve your case today was to revoke probation, resentence you to 12 months jail with credit for time served with conditions outstanding. Do you have any questions about that offer?
What is the conditions outstanding mean?
That means that any conditions that you have will remain outstanding. In other words, some of those conditions may be required to be completed by the Department of Highway Safety and Motor Vehicles or other agencies, depending on, you know, a driver's license or any of those things. Additionally, it means you'll still owe any fines, costs, or restitution or anything like that.
Okay, understood.
All right, any other questions?
All right.
Do you want to accept the offer to resolve the violation of probation?
Yes.
All right, and we previously talked about, you indicated that you wish to waive your right to counsel. You understand that you have the right to an attorney, and if you cannot afford one, I would appoint one to represent you.
Yes, sir.
And you're waiving your right to counsel today?
Yes.
Do you admit that you were placed on probation in Collier County on December 20th, 2019?
Yes.
Do you admit that you had violated the following conditions of your probation? Count 2 for not paying the monthly probation fee as required.
Yes.
Count 10 for failing to pay fines and court costs, failing to pay restitution to victim number 1, and failing to pay restitution to victim number 2.
Yes.
Condition 12, failing to any alcoholic beverage, failing to provide proof of enrollment or completion of DUI school, failing to provide proof of completion of mental health outpatient counseling, failing to provide proof of enrollment or completion of the victim impact panel, and failing to provide proof of completion of the 10-day vehicle impoundment.
Yeah, yes.
And you've already told me that you've read the violation of probation admission form.
Yes.
Did you understand all of the rights and explained on that form?
Yes.
And you understand that you're waiving those rights by entering your admission today?
Yes.
Do you understand that your admission will be used against you in a deportation proceeding if you're not a United States citizen?
Yes.
Are you under the influence of drugs, alcohol, or medication?
No.
Ms. Bonilla, any additional questions from you?
No questions from the state, Your Honor.
All right, Mr. Ward, I'll accept your admission to violating the terms and conditions of your probation. Find it knowingly, voluntarily, and intelligently entered upon a factual basis and in your best interest, revoke probation, sentence you to 12 months jail with credit for time served with conditions outstanding. Thank you, Mr. Ward. Good luck to you. All right, thank you, Naples Jail. What? There's no probation. I just revoked probation. Unless they've resolved it. So, you need me to look at that again, Natalia?
No, it's not.
Okay. So yeah, it can't be a condition of probation because we've revoked
I
probation.
know, it's just that you can tell that anytime there's jail, we have to pick
Either
Because
or.
Yeah.
Either.
By probation or as condition of probation, because that affects the back, but I will run by my supervisor.
Okay, yeah, because that doesn't make sense on a violation of
I
probation.
know. That's what we do.
Okay, all right.
Thank you.
All right, you're welcome. All right, I believe that concludes both violation of probation dockets.
Yes, Your Honor.
Okay, all right. Let's, Natalia, let me know when you're ready to switch back to Judge Brown's docket because I have an attorney with us.
Judge, may I be excused, please?
Yes, thank you, Ms. Bonilla. We'll see you back at 1:30.
Yes, Judge. Take care.
Thank you. All right, let me switch over to Judge Brown's docket. Judge Brown?
Yes.
That's what I'm showing also. Okay, you're ready?
I'm ready.
All right, let's go back to Judge Brown's docket. We have Mr. Carney with us. Good morning.
Good morning, Sir. Lee Carney here for Dennis Ray Shalal.
All right, that's case number 13CT963.
Yes, sir. I have a motion here to either have community service hours that have been submitted as approved, or the option to buy out the community service hours. The community service hours, the probation office has indicated that they would not accept what I had filed. And at this point, it's either I'd request the court to review it to see if they're acceptable, or have the option to purchase a community service hours, buy them out.
All right. All right, Mr. Rusinko, what's the state's response?
The state would object. This defendant had a warrant out in 2014 for a violation of parole, absconded for over 6 years. According to probation, there's plenty of acceptable places he can complete his community service hours, and he also owes $150 in probation fees.
That is correct. And I believe a vehicle impound affidavit has been filed. He has provided money to pay for outstanding fees. I need to file that with the court or the clerk and pay that to the clerk.
Doesn't your client live in Michigan?
He's out of state. Yes, I believe he's in Michigan.
Let me ask probation, who's here. Is there a reason why probation wouldn't accept the hours that were shown completed in Michigan?
We have a letter that we received, and it was dated December 4th, 2017. We have tried to contact the agency. We have emailed this morning to the service, and they tried calling again. They've got messages, voicemails. We can't verify the hours of work. But I can read the letter if you want.
All right, I have a copy of the letter here.
Judge, to me, that letter, I mean, it seems as reliable as any other type of writing or submission for community service hours.
How many hours was he required to complete?
60 hours.
And if the court accepts this, that would complete that 50 hours?
That's what indicates, the letter indicates 50 hours.
Did county probation verify that there is a Genesee County Agricultural Society by reviewing, by Googling it? Or,
center organizer, she tried calling, and I don't know if that's verified, whether it's or not. How she said that. She couldn't hear. It has no voicemail, it just goes straight to a voicemail, she just leaves a message, there was like no, it didn't seem like it was a business number.
All right. Any objection to the court Googling Genesee County Agricultural Society?
Okay.
Not from me, sir.
All right, the court has Googled Genesee County Agricultural Society. It does indicate the same address and phone number listed as that on the letter. The Genesee County Agricultural Society appears to run the Genesee County Fair. It does appear to be a 501c3 nonprofit organization. Not receive federal, state, or tax county dollars. Is located in the same address. All right. Motion to accept community service hours is granted. The community service hours performed by the defendant at the Genesee County Agricultural Society shall apply to this case.
All right, sir. Do you need me to submit an order or?
Yes, if you could email that to my judicial assistant and we'll get that filed today.
All right, that's fine, sir.
All right.
All right, and for Mr. Okay. Just to, excuse me, sir, to the state and to probation, I will be paying the outstanding fees and then filing motion to set aside the bench warrant once he's completed everything.
Thank you, Mr. All right, very good. Did you all hear that?
Thank you, sir. That is what I have today. Thank you.
Wait, hold on, Mr. Carney.
Yes, sir.
Are you going to file a motion to waive the vehicle impoundment?
He has done the vehicle impound, and I believe I filed an affidavit for that purpose.
You filed an affidavit for that purpose?
Yeah, it's showing that the vehicle was impounded.
That it was impounded.
It was impounded, yes.
Looks like filed January 21st. Okay. All right. Anything else then? Okay. All right. Thank you, Mr. Carney. We'll be expecting that proposed order.
Yes, all right. Okay, thank you.
Thank you.
Mr. Rogers waiting outside the door for the state attorney.
All right, Mr. Rusinko, are you going to be coming to the courtroom?
Yes, Your Honor. I just was wanted to see if the pro se defendant was able to show up.
No pro se defendant has shown up. Do we also have I'm showing two cases with Mr. Bourgeon. Have you heard from him?
I'm sorry, for who? Oh, no, you know what? I thought that was set for 11.
It is. All right, if you'd like to go ahead and come down, and if they show up here or on Zoom, we can address it here, whatever your preference is.
Thank you, Your Honor. I'm on my way. Thank you.
All right, very good. I'll go ahead. Thank you. We're gonna take a brief recess, but I'm not gonna leave the bench. All right. We've got Mr. Gorjan via Zoom. He's here for Eric Shane Terrell, case numbers 18CT2900 and 18MM2801. Good morning, Mr. Gorjan.
Good morning.
All right, we've got your client on Polycom here, and I've got Mr. Rusinko from the state in the courtroom. I believe you've got a motion for bond reduction.
Yes. By the way, I just got I had to call court admin that I never got this email saying that it was changed Zoom codes. So I just wanted to let the court know that.
All right. Well, it just happened yesterday afternoon.
Yeah. Let me know when I can begin. Or I don't see Mr. The prosecutor or Mrs. or Mrs.
Mr. Rusinko's in the courtroom.
Oh, I may begin, Your Honor.
You may go ahead.
And thank you. Defense attorney is Sabu Gorjan. Your Honor, I have filed this motion to set bond. Unfortunately, the title was reduced bond, but it's a motion to set bond. Your Honor, my client was arrested back in December 10th, 2018 for a DUI and a resisting. The bonds were set at $1,000 and $2,000 for the DUI and the resisting, respectively. Now, on July 29th, 2019, my understanding is that he failed to appear for a trial, and thereof, the bonds were revoked with a hold no bond. And he was subsequently arrested on August 17, 2020, and the warrant was served on him. Since then, in August of 2000, I'm sorry, shouldn't be waving. Since August 17, 2020, he's been sitting there without bond. I could not get any other information as far as if he's failed to appear or his criminal history. He is an out-of-stater, Your Honor. So as far as I know, I don't have any information on that. But what I'm asking right now is to reset the bonds at the original amounts of $1,000 for the DUI and $2,000 for the resisting without violence.
All right. Would you like to take any testimony from anyone?
Yes, Your Honor. If the defendant can raise his hand and swear, and I'd like to take his stake.
All right. Mr. Terrell, will you raise your right hand to be sworn by the clerk?
Whoever gets a little messed up right now because I had a battery while I was in there and I had really items on my hand.
Okay, that's all right. As best you can.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Gorjan, your client has been sworn in.
Let me know if I'm loud enough, Your Honor. Mr. Terrell, if the court were to set your bonds in the original amount, would you appear for your court dates?
Yes, I will.
Okay. If the court were to impose any other conditions, such as scram, which is an ankle monitor, would you be able to pay for that in order to get out, or you can't afford that?
I can't afford it right now, unfortunately.
Okay. To the best of your knowledge, I know you have a prior DUI. Do you have any failure to appears other than this one?
Never, no.
Okay. And I do not have your criminal history. Do you know what other crimes other than one DUI that you were arrested and convicted of in Illinois? Do you have any other convictions?
No, I was arrested on the case.
Okay.
That happened right before this, which is another reason why I wasn't cooperating, because I felt like I was being harassed after they hit my car from behind and pulled out a run. I come home.
Okay. Have you ever been arrested for a felony, sir?
No, never.
Okay. That's all I have, Your Honor.
Any questions from the state? All right. Thank you, Mr. Terrell. Mr. Terrell, you can put your hand down.
Oh, thank you. A little tired there.
All right. Anyone else you'd like to call as a witness, Mr.
No, Your Honor. No, Your Honor. Your Honor. I'm sorry.
Anything else then from you, Mr. Gorjan?
No, Your Honor.
Well, I was more
Mr. Terrell.
I wanted to run the charges in criminal.
I don't know why they're not doing that, but
Mr. Terrell, we're here for the motion to reduce bond. We'll call on you again if we need to hear from you. All right, state any response?
Yes, Your Honor. The defendant failed to appear on July 29, 2019. He absconded for over a year. He was picked up on 8/17. He has a pretrial conference set on the 27th. There's a plea offer in this case. The state asked that he be held no bond based on his previous failure to appear and his own testimony saying that he was not cooperating with authorities. I don't think he should have bond at this time.
All right. Anything else then from you, Mr. Gorjan?
Yes, Your Honor. I didn't get the last part. He said, the prosecutor said that he has pretrial on, he didn't say the month, he said the 27th. I'm assuming it's January 27th.
Appears to be.
And I did not catch the other, what he was talking about. I'm sorry, if he can repeat that.
Could you repeat your other argument?
And can you go slow?
The defendant's testimony about not cooperating. The defendant testified that he was not being cooperative with authorities. That's another reason why I don't think bond should be set in this case.
Okay. May I respond, Your Honor?
You may.
Your Honor, I don't think bond conditions require that I understand that he has to be cooperative, but not cooperating with law enforcement is a condition, whether to release or hold a person in custody or as a reason to increase or decrease a bond. So I don't think this non-cooperation is an issue as far as setting a bond. The bond is to be set to ensure Mr. Terrell's appearance in court. He has, to the best of my knowledge, he hasn't shown any other indication other than his failure to appear on July 29, 2019, that he has issues appearing for court. In the alternative, if the court has some concerns, I don't see a reason why he should be held no bond. This is not a case where Mr. Terrell's been charged with a very serious felony. It's not a homicide. So I think it would be unconstitutional for him to be held without bond. So therefore, we would be asking for a reasonable bond on this case, Your Honor.
All right, well, having heard the testimony from the defendant, the arguments from counsel, having reviewed the court file, defendant's motion to reduce bond is denied. Should we go ahead and have the pretrial conference now?
I'm sorry, sir.
You want to wait for Judge Brown tomorrow?
Right. I'm sorry, there's a motion to set bond. You said reduce bond.
I'm sorry, that's the way it was titled.
Yes.
So
I made that clarification that I mistitled it, Your Honor. I know I mistitled.
All right. Well, I'll reclassify that. Motion to set bond is denied. All right. I see that you're set for pretrial conference tomorrow. Judge Brown is scheduled to have jury trials February 8th, to let you all know. So I think we'll just let it stay on tomorrow's pretrial conference docket.
I could do the pretrial right now. It makes no difference for me.
right now, I'd rather do it tomorrow for a judge. That's okay.
Your client's requesting that it be left on tomorrow's docket.
All right.
Are you adopting that request?
No, I mean, we could address it now. I mean,
Can you call me later, because I might want to get a new lawyer as well.
Sounds like we better leave it for tomorrow, Mr. Gorjan. All right. All right. Thank you, Mr. Gorjan. Thank you, Mr. Terrell.
Have a nice day. Thank you. Bye-bye.
Have a blessed day, Aaron.
Thank you, you too. All right. That brings us.
Hi.
Hello. Hang on.
Okay, I have no idea how to do this or what to do. I'm sorry.
That's okay. All right, one final case, Mr. Rusinko on Zoom is this Jediah Solomon?
Judea, yeah.
Jediah, thank you, sorry.
No.
Case 15 CT 1596.
And my apologies. I'm a little under the weather, but you know, I have asthma.
Sorry.
Things just happen. It's fine.
All right, we're here on a motion. Mr. Rusinko, why are we here on this case?
The defendant filed a motion to modify a sentence. That motion had to have been brought within 60 days, so the court wouldn't have jurisdiction to modify the sentence.
All right, give me a moment.
Sure. Excuse me.
All right, Ms. Solomon, you're requesting that the ignition interlock be waived, is that correct?
Well, I was hoping that that was something that could happen. I have asthma, and I got the DUI so many years ago, and it's affected so much of my life up until this point. And I think that just, you know, my ailment that I can't shake it. I was born with it. It's definitely going to deter me from being able to get another car. I'm not able to blow into that thing. Like, it's super duper hard. It's like just trying to do it, like I can't breathe. It sucks. So it scares the crap out of me to like even like the thought of driving behind the wheel of a car. And I think it like you have to blow in it like every like 30 minutes or something at random or something. And just to blow in it while I'm just like sitting still, it like can almost give me an asthma attack. It's like too hard. I don't know how people do it personally. But then again, I have asthma. I don't have the regular lung capacity of a normal person.
Ms. Solomon, do you have any medical documents to provide to the court?
No, I don't.
Okay.
I didn't really know what to do about it.
Okay. Do you?
I can provide those medical documents though. I've had asthma my entire life. My entire life.
Okay. So it sounds like you could have medical documents to provide to the court.
Yeah, totally. Yes, for
Have
sure.
you attempted to obtain an ignition interlock device before?
Yeah, so about that, no. A friend of mine had one in the car because he had like some situation that happened. And I was like, oh yeah, I can't even do that. Like I can't blow into that thing or whatever. I was like,
all right, Ms. Solomon, I'm going to stop your testimony. Okay, so I'm going to deny your motion at this time without prejudice to refile with appropriate evidence attached to your motion, okay?
what's that mean?
I can't provide you with legal advice, Ms. Solomon. If you need legal advice, you'll have to seek that from an attorney.
Well, what should I do now?
I just told you.
Oh.
If you
I
need
mean, is
legal-
there any way that I can we can do this when I have all of my medical documentation?
That's what I ruled.
Oh,
Okay?
okay. So do I like come back? How do I reschedule this? Or like,
I can't provide you with legal advice, Ms. Solomon. You'll have to figure it out or talk to an attorney, okay?
I'm so confused. I'm sorry.
That's all right. Thank you, Ms. Solomon. Have a good day.